Coming up Sunday night on The Attorney is going to be joined by Josh Wright of the firm of Hollis Wright. We're going to be talking about insurance relative to car accidents, but there are some creative options even when it seems like you're out of options with an accident, huh?
No question, and there's a lot of times, David, when individuals in a car accident do not have insurance or they don't have sufficient insurance. What we're going to be talking about on Sunday with Whit Drake, who's a great lawyer in this area, is creative and also thorough ways for lawyers to earn their keep, if you will, to make sure that the case is being evaluated from all potential angles to bring to bear any potential claims that can be asserted, whether it's a dram shop claim, it's a claim against an employer, it's a product liability claim, or just a regular car accident claim.
Sometimes it may look like you're at a dead end, but a good lawyer can help you find a way. We're going to talk about that on Sunday night on The Attorneys. It's going to take place right after the late news here on WVTM 13 News. So, Josh, we'll see you Sunday.
Sounds great. Look forward to it.
We'll look forward to seeing you Sunday as well.
Car crash cases, defective products, dangerous drugs, injuries, and abuse. Across the state of Alabama, the attorneys, proudly sponsored by the law firm of Hollis Wright, are here to serve you. Your tough legal questions answered by our experts. The attorneys with Josh Wright from the law firm of Hollis Wright and host David Lamb.
Good evening and welcome into The Attorneys. We appreciate you spending your Sunday evening with us. Tonight we have a panel of experts to deal with a topic of interest to you and that matters to you, chock full of a great deal of valuable information. We'd love to have you be a part of the conversation. There's ways you can call, text, email, and join the conversation. Also, remember, an attorney is standing by, so when you pick up the phone and call, you have the opportunity there to speak with an actual attorney. Would love to hear from you and have you join our conversation tonight. To head things off and to head them up, Josh Wright of the firm of Hollis Wright. Good to see you, sir.
Good to see you, too. I hope you've had another great week.
Have indeed. Thank you.
Family good?
Everybody's pretty good.
Life good?
The Wrights? Are the Wrights good?
Wrights are doing great.
Good.
Wrights are doing fabulous. They're doing better than we should.
Better than we deserve.
That's right. That's exactly right. Well, somebody else doing great is to my right, Whit Drake, with the Drake Law Firm, who's going to be on with us tonight. And Whit is a great lawyer, a good person, father of three, and a guy in this area that is really an expert in the area we're going to be talking about today, which is kind of the realm of accidents, car accidents, for example, but other potential claims that people may have other than just against the person that caused the accident.
Okay.
And so we're going to be talking about those topics today. And in today's creative world of lawyering, lawyers have to be thorough enough and creative enough to try and find other theories of liability, because a lot of times, even though people are supposed to be carrying insurance and they cause accidents, they may not have insurance or their insurance may have lapsed. Right. And so lawyers have to be creative and thorough enough to be able to find the defendants that are necessary in order to compensate injured victims that have been injured at no fault of their own. And so Whit's going to be an expert to talk about that today. So first of all, thank you so much for coming on today. We really appreciate it.
Glad to be here. It's an interesting topic. So many people in Alabama do not have auto insurance coverage, Josh, as you know. And so today we're going to talk about different ways you can make a recovery for your injuries when they don't have insurance coverage.
Tell us a little bit about your practice, because you've been doing this for a long time.
I've been practicing law for 26 years. When I first started practicing law, we had a lot of different kinds of cases, very few accident cases, quite frankly. But now, as I'm sitting here 26 years later, we do nothing but personal injury, and I would say 80% of our cases are car accident cases.
Let's kind of start from a jumping off point here. This topic, do you think it is about being a really thorough lawyer to find all potential avenues of recovery for a client to be able to evaluate that case? Do you think it's lawyers have gotten creative to find other theories of liability because it's become so competitive in the marketplace? What do you see?
Absolutely, because the tort reform efforts over the last decade or so have cut back on the different causes of actions that people who have a serious injury have. A lot of times in a car accident, a lot of times people will say, well, the only thing I can do is get money from the person that hit me, and that's simply not true. You have a variety of car accident-related claims such as product liability, your own insurance, your underinsured or uninsured coverage, as well as possible what they call dram shop cases against drunk drivers. So, yes, I have.
Let's kind of take these things one at a time, and let's start, if we can, with uninsured motorist coverage. We've done entire shows on uninsured motorists. I mean, it's a complicated area of the law that's difficult sometimes for people to understand the importance of uninsured motorist coverage, but just kind of talk generally about UM coverage and how it applies in society.
Okay. Alabama law requires all drivers in the state of Alabama to have what I call coverage. That can be short for uninsured motorists or underinsured motorists. And Alabama requires everyone to have at least $25,000 in coverage. But there's an exception to that. You can sign a written rejection, and a lot of drivers in Alabama, unfortunately, sign a rejection of the underinsured coverage. And when they do that, and a lot of times they'll get hit by somebody who doesn't have insurance coverage, and then they're out because they don't have any avenues of recovery. So underinsured coverage, underinsured motorist coverage is something that every Alabamian is supposed to have, and every Alabamian should have. Never reject it, always get it. And even though Alabama law requires $25,000, I personally think everyone should have at least $50,000 to $100,000 in underinsured coverage.
And let's dissect this just a little bit. Whit's exactly right. When we talk about uninsured motorist coverage, we have really two kinds that you can define. You have uninsured, that is in circumstances where you're hit by somebody that did not have a form of insurance. Mm-hmm. You're generally not going to have that problem when you're dealing with commercial vehicles. They're going to be guaranteed in order to have CDL licenses, in order to have DOT numbers to operate those vehicles, they're going to have insurance. But an individual driver who's operating a vehicle, insurance could have lapsed, even though the law requires that they have insurance. And so uninsured is you are covering yourself and protecting yourself under circumstances where someone else did not have insurance. Underinsured is a little different. That is where you're injured significant enough that you get into your own coverage because the person who hit you didn't have enough coverage. So I've got $100,000 in medical bills. Person that hit me that caused the accident only has $25,000 of that coverage. I hope I have a form of coverage in order to protect myself. So that's kind of the general way that the law works and the way that insurance works. And as Whit was saying, and I agree with him 100%, every person should have this. It's not expensive. Mm-hmm. It's what I call rainy day coverage, and it's really to protect people in circumstances where other people are either under or uninsured.
Yeah, I can just say this personally. I'm more concerned with having underinsured or uninsured coverage on my policy than I am liability. Yeah. In other words, it's more important to me that I'm protected in the event that somebody who doesn't have insurance hits me.
Mm-hmm. Have a question right along these lines. I was involved in a hit and run accident. I have full coverage, but I do not know if the driver that hit me has any insurance. Can I make a claim on my underinsured motorist coverage?
And the answer is yes. A lot of times that's called a phantom vehicle accident, where somebody hits you and then they vanish. Under Alabama law and under Alabama insurance policy, you can make a uninsured claim against your own policy as if you knew the identity of the driver, as if you knew where they were. In other words, you can claim on your own insurance under that situation.
You'd agree with, would you not, Whit, that in those circumstances, especially when you're dealing with uninsured motorist coverage and dealing with adjusters, it's a good idea to have counsel on your side?
Absolutely, absolutely. I would never, unless it's just pure property damage, we wouldn't need an attorney. But if you have any injury of any severity that has any permanency, any element of permanency, future lost wages, future medical bills, absolutely you need a lawyer. Why? Because Alabama law has multiple procedural hurdles that you must take care of before you can make a claim, such as providing notice to your insurance company and making that notice early enough so they don't say, oh, you didn't tell us about this. So absolutely you need an attorney.
And Whit's exactly right. If you make the mistake of not notifying the right carriers at the right time, you can waive the coverage that you had applicable to you. Lawyers take these cases. We talk a lot about contingency fee contracts, and we harp on it for a reason. It's because a contingency fee contract gives the individual victim that has been injured in an accident the same level of coverage and service from a lawyer's perspective as the corporate bar would have, as the defense bar would have, as the trucking companies have. And so you want to make sure that you use the benefit of the contingency fee contract to protect yourself and make sure your claims are properly evaluated and investigated to make sure that you're covered.
Time for us to take our first break of the evening.
We're going to talk about, before that, hold on, we're going to talk about one thing.
Let's do it.
First of all, I like your title, man. We're going to talk about something. Here's what I want to think about, though. When we come back, I do want to talk about an important topic, and that is parent responsibility and other adult responsibility in circumstances, for example, when your children do something like riding four-wheelers,
Right.
driving in vehicles, what responsibility can they have? Because that's something that we all face as parents.
Absolutely. We'll pick up right there. Step aside just for a moment. A reminder as we do so, an attorney standing by. If you'll call that number that you see right there, an attorney standing by to answer your questions and to take your call. If you would rather text or email, you can also do that. Get your questions into us, and I will pass them along to Josh and Whit. Stay tuned. More of the attorneys coming right up.
I'm Carter Clay with the law firm of Hollis Wright. Thanks for watching The Attorneys on WVTM 13. Now we hope you, a friend, or a loved one never need legal counsel for a case. But if you do, the goal of this show is simple: to provide answers and legal counsel when you need it the most. Your call to the show is free, so if you have questions specific to this show or related to other specific legal matters, call, email, or text us to talk with one of our lawyers. You can also follow us on Facebook or Twitter to learn about important legal news that could affect you or your family member. Or simply contact us by going to WVTM13.com and click on the attorney's link. Now we know your time is valuable, so thank you for spending it with us and for watching The Attorneys right here on WVTM 13.
Welcome back into the attorneys. Would love to have you join our conversation tonight. At the bottom of the screen, you see ways you can call, text, email. Join the conversation as we talk about auto accidents and insurance and everything you need to know to make sure that your rights are known as you hit the roadways. Josh?
All right, so a question that I often get, I'm sure you have gotten this, is a parent responsible for the actions of a minor child, call it a 12, 13-year-old child riding a four-wheeler, a go-kart, taking a car, whatever it may be? Do parents have responsibility for that kind of stuff?
Absolutely. Under Alabama law, if you're a parent and your child, say a 15-year-old child, is at home and they bring a friend over, and you allow your 15-year-old child to get on, say, an ATV and ride the other child around, if that other child is injured, then the parents of that child can absolutely sue that parent, me in this situation, for what we call negligent entrustment, meaning I did not use reasonable care to keep that vehicle away from people who should not be driving. So, yeah, and usually in that situation, your recovery is from the homeowner's insurance of the parent who was negligently entrusted that to the child.
You know, and David, a lot of times what we will see in cases is where a parent has a 16, 17-year-old child, and the parent is aware that that minor child has had 3 accidents, 4 speeding tickets, a texting while driving ticket, a failure to maintain a license, whatever it may be. Mm-hmm. And oftentimes what you have to do, and car insurance makes it a little more complicated, but you've got to assess from a lawyer's perspective whether or not the parent was reasonable in allowing that child to continue to operate that motor vehicle and whether they could have responsibility. It's a little different than what Whit was talking about, because generally car insurance is going to be applicable in those circumstances, mm-hmm. as opposed to homeowners, because homeowners coverages will generally have what's called an exclusion for anything that's auto related. It's something you got to look at. And good, thorough lawyers don't just come back to somebody and say, all right, yeah, you've got a car accident case.
Right.
They say, all right, we've evaluated all these things, and here are the potential claims that you have. Let's talk through what makes sense and what does not make sense to file a suit. And I know that's part of kind of your responsibility as a lawyer, is to really sit down with those folks. And sometimes the answer is, I'm sorry, but you don't have a claim here. Yeah,
absolutely. There have been several times in my career, many times in my career, where I'm talking to somebody who has a severe debilitating injury, and I just say, I'm sorry, I can't help you. Or the person that did this doesn't have insurance coverage. Or you rejected underinsured motorist coverage. So yeah, I hate to do that, but I just look them in the eye and say, there's nothing here. But, and Josh is right, with good lawyering, the majority of the time, an avenue can be found to adequately compensate that injured person if you do your research.
Let's talk about one more of those avenues, and that is an employer. Talk just generally about the importance of evaluating in a car case or an accident case, whether an employer can have some responsibility for the actions of their employees.
Yeah, that's a good point. Alabama law requires or allows all employers to be responsible for the negligence of their employees who act negligently in the course and scope of their employment. When I get an accident report in a car accident case, I think the first thing I look at, other than insurance coverage, is whether or not that person was on the job, the at-fault party, whether or not they were working for someone, because then you have a duty as a lawyer to sue that employer because their agent was negligent and caused your client's injury. And that's the way it is in all jurisdictions, including Alabama.
And you know, in those cases, for example, we've done shows on trucking cases where a trucker is vicariously liable, or through vicarious liability, the employer to that trucker is the one that's responsible. And so, you know, a lot of this is evaluating if somebody was in the line and scope of their authority, and if they were, whether or not the employer has some responsibility for those actions. You know, I'll give you a shining example of a recent case that I had of a gentleman that rear-ended somebody and caused significant injury on 280. And the question was, he was on his way to lunch, even though it was within his general operation and kind of general day to use a company vehicle to go from place to place. He happened to be on his way to lunch, and part of the, I think, good lawyering on our end was to be able to establish that that still was in the course and the scope of his employment, because it was common for him to go to lunch while using a company vehicle. And those are complicated issues.
Right.
Sometimes they go your way, sometimes they don't.
And Alabama law says that if you're in an accident while using a company vehicle, it's presumed that you're in the course and scope of your employment.
I go to a question on a different mode of transportation, and one that you were talking to as we went to the last break. A question here: my 13-year-old son was over at a friend's house. His friend's parents let him ride a four-wheeler with their son. While riding, his friend lost control, crashed, resulted in significant injuries to my son. Can he make a claim against the parents for negligent entrustment?
Yes.
Or can he make a claim, period?
Absolutely. Another thing I would look at in that situation is perhaps a product liability claim against the ATV manufacturer to see if something about that was designed effectively. But the answer to that question is yes, you can make a claim for negligent entrustment against the parents who negligently allowed 13-year-old boys to drive ATV.
Let's go to product liability, because you just touched on that. I know it's something that our firm does a lot of. I know you evaluate claims for those purposes too. Talk a little bit about what we mean when we talk about product cases when it comes to an auto accident.
Under Alabama law, it's sometimes called crashworthiness. And the question is, if you're in a vehicle and something about that vehicle injures you, the airbag doesn't deploy, the seat belts don't work, or you roll over and the roof crushes, the question is that vehicle crashworthy? Now, Alabama law doesn't require vehicles to be like a Sherman tank. You got to look at the speed of the vehicle. If you're in a 90-mile crash, you're probably going to be hurt regardless. But if you're in a severe accident and you've been injured because of a defective airbag, seat belts didn't work, the tire blew out or whatever, you can bring a product liability claim for that injury, and that claim in addition to the car accident claim, the underinsured motorist claim, or a negligent entrustment claim.
You know, and one of the things that's super important when you're dealing with product suits is to get to a lawyer after an accident quickly. Don't delay. And the reason that we say that is not to pound the drum of come to us as a lawyer. Right. Go to somebody. And we often argue that on this show. You don't have to come to us. You don't have to come to Mr. Drake's firm. Go to somebody. And the reason for that, David, is that what happens is these vehicles get destroyed. They get sold immediately, and you've lost your right to be able to evaluate that vehicle from a product's liability perspective. Without the product, it's awfully difficult in Alabama to pursue a claim. I would say impossible to pursue a product claim in an auto context. So at the end of the day, get to a lawyer, whoever it is, so that they can secure that vehicle, they can evaluate that vehicle, get experts involved, and do the things you need to determine, is there something about that vehicle that was recalled or defective that may have contributed to the injury and the accident that the person had.
Okay.
Absolutely.
All right, we'll step aside right there, but we'll come back. Our final break of the evening. When we come back, more of the attorneys. Also a reminder of how you can get in touch with us: call, text, email. You can find the firm of Hollis Wright if you'll search that term on Facebook, and on Twitter there at Hollis_Wright. Great ways to check them out there on social media. Stay tuned. More of the attorneys coming right up.
I'm Josh Wright with the law firm of Hollis Wright. If you've ever served on a jury, You may have wondered why there are gaps in the evidence you're given at trial. In today's Legal 4-in-1, we're answering the question, is there insurance to pay the verdict? Know this, just because the lawyers never mention insurance in a trial, it doesn't mean there is not insurance to pay the verdict. Rule 4-in-1 of the Alabama Rules of Evidence states this: evidence that a person was or was not insured against liability is generally not admissible or allowed to be discussed at trial in front of a jury. The reason for the rule is simple. A jury could award more money in a case if they knew the defendant had insurance to pay for it. But the reality in our state is this: in almost all lawsuits that get to a trial, insurance is there to pay judgments awarded by the jury. For example, all automobiles in Alabama are required to have liability insurance. Coverage can range from $25,000 up to $1 million in these cases. In theory, all car crash cases that get to trial should have insurance available to pay any verdict awarded in the case. Trucks have to carry anywhere from $750,000 to $5 million worth of insurance. Unfortunately, you'll never hear that during the trial. Even in medical malpractice cases, the doctor has liability insurance to help pay a judgment. That's something you won't hear during trial because the rules just don't allow that testimony. Yet almost all judgments against a doctor involve liability insurance. Please remember, your call, email, or text to the attorneys is free. All of us at Hollis Wright want to help answer your questions on real issues you face. Remember, a competent lawyer will respond to every question you send in. That's our promise and pledge to you.
Welcome back in to the attorneys. Appreciate you being with us. A few minutes remaining, so if you have a question, now's the time to get it in. Call, text, email the information there at the bottom of your screen. That firm fact leading right in perfectly to a question that we have. The question for you, Whit and Josh. My underage son was injured when he crashed his car after becoming intoxicated at a local restaurant. Do I have any legal options?
Okay. First of all, I can see two possible claims arising out of that. If the son injured somebody else,
right,
they could sue both the son and the restaurant. It'd be called a dram shop case. However, the parents of the son can also file a claim against a dram shop claim against the restaurant under what we call a Civil Damages Act, where they get punitive damages because the restaurant sold the liquor to their son. But the bottom line is the person drinking can never make any recovery. But the person drinking, if they injure somebody else, yeah, they can. But the parents can bring a claim.
We've done a lot of shows just on dram shop alone, and it's unfortunate in Alabama, but you know, a lot of the accidents that happened are impaired based on fatigue, alcohol, drugs, etc. I mean, we have a lot of cases going right now that unfortunately involve alcohol, and so having a lawyer that steps in to evaluate those cases and to determine whether or not there's a dram shop component to the case is super important, especially in those accidents that take place in the dark, after midnight, etc. You know, my mom used to always tell me, and I still hear it to this day ringing in my ears, nothing good happens after 11. Well, some people would extend that to 12, 1, but nothing good happens after 11. And although that is somewhat humorous, there's a lot of truth to that when it comes to car accidents, unfortunately. And alcohol and cars don't mix well. And it can cause some serious problems. So having a lawyer that can evaluate those types of cases is really important. What are you seeing in today's kind of, what's a hot area right now outside of just traditional car accidents? Are you seeing a lot more dram shop cases? Are you seeing a lot more employee relationship cases? What are you seeing?
I'm not seeing as many dram shop or alcohol related claims as I used to see. I'm seeing more product liability claims. Whether in the old days it was the seatbelt and airbag, now it's a roof crush, tire blowouts, steering mechanisms, a lot of different things. But in those cases, which we call crashworthiness cases, you usually have to have a pretty severe and catastrophic injury to justify the money and expense you have to put in that kind of case.
Go on, I'm sorry.
And so, but the number one thing that I would tell anybody who's listening here today, have enough insurance coverage, have underinsured motorist coverage, and have as much as you can afford.
Yeah, you know, at the end of the day, when we talk about uninsured motorist coverage, you know, it's pretty insignificant. I get this question a lot, and that is, somebody hit me and they don't have enough coverage to compensate me, or they don't have any coverage whatsoever. If I make application to my uninsured motorist coverage or my underinsured motorist coverage, if I make application to that, does that mean that my insurance is going to jump? Does it mean it's going to go up? And the general answer, and I've heard this from adjusters and lawyers alike, the general answer is if it is a non-fault accident where you are not the person causing the accident and you are making application to your uninsured motorist coverage because you paid for that coverage, generally it should not impact your insurance. Now, there are certain qualifications and there's a tiering rating system that's used, and you know, you may see insurance premium increases, but for the most part, if you're not the at-fault driver, you should be in good shape to make application to your uninsured motorist coverage. And that's just something that we pay for on a daily basis to protect ourselves in the circumstances where folks are injured.
And my clients ask me that all the time, and I say generally not, and they say why not? I say because you were not at fault. They'd rather have you paying the premiums than stay insured. So I agree. Yeah.
Contingency fee contracts, kind of the importance of that, because it really does allow, and we harp on it a lot on this show, but for you, when somebody comes in your office, you know, you're not charging them hourly, you're actually taking a case on a contingency, especially in the car realm, in order to spend the money for the experts, et cetera, to be able to evaluate these cases.
Right, and the contingency is that I'm successful, that I win the case. And if you know, I guess our percentage is probably, and yours is too, probably around 90-something% that we make a recovery for our clients. So that contingency will almost certainly be fulfilled. But they don't ever have to reach in their pocket and pay us money right at a time when they're having medical treatment, they're late on their mortgage payment and all that kind of thing. So that helps the situation as far as them being able to retain the services of somebody who's going to look after their affairs.
You know, one of the things I think makes really good lawyers, that separates lawyers that are doing a good job from the lawyers that really are providing that exceptional help to a client, go to somebody. Get help. The contingency fee contract is a way to protect individuals, and the beauty of the contingency fee contract is, Whit was correct, the contingency is that the lawyer is going to be successful. I will pledge to you this, and I'll promise you this. With a lawyer involved, negotiating with an insurance company, you're going to get more out of that case than you would without a lawyer involved. That will justify the payment, if you will, of the lawyer through the contingency. And there's a number of reasons for that. That's a whole nother show. But it's worth your time and effort to go speak with counsel, no question.
A good conversation tonight.
Thank you for being on. Appreciate it.
Glad to be here.
Thank you all for being with us, and thank you for being with us as well. I hope you got something out of this tonight. If you have a comment, I'd love to get your feedback. Call, text, email. That information is still there on your screen. However we can help, and we'd love to hear from you. We appreciate you being with us, and we'll look for you next time right here on The Attorneys.
Thanks for watching The Attorneys, sponsored by the law firm of Hollis Wright.
I'm Carter Clay with the law firm of Hollis Wright. Thanks for watching The Attorneys on WVTM 13. Now we hope you, a friend, or a loved one never need legal counsel for a case. But if you do, the goal of this show is simple: to provide answers and legal counsel when you need it the most. Your call to the show is free, so if you have questions specific to this show or related to other specific legal matters, call, email, or text us to talk with one of our lawyers. You can also follow us on Facebook or Twitter to learn about important legal news that could affect you or your family member. Or simply contact us by going to WVTM13.com and click on the Attorneys link. Now we know your time is valuable, so thank you for spending it with us and for watching The Attorneys right here on WVTM 13.